Hi, thanks for watching this webinar where I'm going to talk to you about how the Legal Ombudsman approaches complaints. This is a way for you then to understand the approach that we will take if your client comes to us with a complaint, but also to provide you with some tips on how to handle complaints internally in the hopes that you'll be able to resolve them before they come to us. There are two stages which guide us at the Legal Ombudsman when we're investigating complaints. Was the service reasonable in the circumstances? And did any service failing have an impact on the complainant or the outcome of the work? Looking at the first test, the Legal Services Act 2007 and the scheme rules say that a complaint is to be determined by reference to what is, in the opinion of the Ombudsman making the determination, fair and reasonable in all the circumstances of the case. In reaching their determination, Scheme Rule 5.37 states that the Ombudsman will take into account what decision a court may make, the relevant regulator's rule of conduct at the time, and what the Ombudsman considers to have been good practice at the time of the act or the omission. What is reasonable in the circumstances of the case? The most common answer that any Ombudsman would give you is, it depends. That's because there's a huge number of factors that go into whether we consider a service has been reasonable. Generally speaking, you have perfect service and you have really poor service. The vast majority of complaints that we see sit somewhere on this large sliding scale. And remember, we're not expecting a perfect service, but the point at which we draw the line and say that's unreasonable will depend on a number of factors. So we'll take into account the characteristics of the complainant. We will expect a firm to take the client's needs into account and to adapt their approach accordingly. For example, we investigated a case where a firm was defending an illiterate customer in criminal proceedings. The firm talked to him about how they could best communicate with him, including whether he needed any support from a third party. This demonstrated that the firm had adapted their approach to take account of the customer's needs. However, in a different case, a firm sent a customer letters full of technical and Latin phrases, despite knowing that this customer had a learning difficulty. As the customer had reminded them on a number of occasions, letters should be in plain English and that any difficult concepts would need to be explained. Their failure to do that then led to the customer being understandably and avoidably frustrated. We determined in that case that this was poor service. As well as the complainant's characteristics, we also think about the service provider's expertise. We'd expect service providers to have the appropriate skills and knowledge to be able to properly advise a customer about their case. So if you're a conveyancing firm, we expect you to be reasonably well versed in the home buying and selling process. If something extremely unusual crops up, saying that you're unfamiliar with it and seeking additional assistance isn't poor service. But if you're advertising yourself as the leading specialist in a particular type of transaction, then we would expect that this is demonstrated in the service that you're providing. Finally, we will also look at service levels. One of the most common drivers of a complaint is a mismatch between customers' expectations and the level of service that's provided. The Legal Ombudsman doesn't set how fast you should respond to things. We simply expect that clients are kept reasonably up to date and that you respond in a reasonable time frame. What is reasonable will hinge on what you've told them at the beginning within your initial letters. If you said you'll get a response to everything within 2 working days, then we'd expect to see that you've adhered to this. If a complaint comes in that says the conveyancer didn't give them an update, but there was no update to give and your client care letter said that you would only tell them things as and when there were updates to give, then it's likely we're to say that that was reasonable. So if we look at this in terms of how we would determine individual complaints, we'll always look at each case individually. I'm sure you'll appreciate that we often see similar cases. However, it's really important that we keep in mind that no case is really the same. We can learn from earlier complaints on the same area of complaint, but we need to look at each complaint individually. We'll also clarify exactly what it is that the consumer is complaining about. What this means is that we really spend time at the front end of our process scoping the complaint to understand the issues that go to the heart of the matter. We'll also think about the characteristics of the individual, the complexity of the work, and the service provider's expertise and service standards. Just to give an example here, I dealt with a complaint about a firm giving a complainant the wrong information about the level of stamp duty that would be payable on completion of the purchase of a property. From the start of the retainer, this client had been told that stamp duty land tax would be approximately £18,000. She had told the firm on more than 3 occasions that she owned other properties and even asked them whether this would impact on the stamp duty land tax payable. However, they hadn't taken this into account or answered her questions. On the day of exchange, the firm told the complainant that she would need to find an additional £18,000, as she would have to pay a higher rate of stamp duty of £36,000. It was clear that this was a surprise to the complainant. She expressed shock and frustration immediately, but also confirmed that she was able to make that additional payment from her savings. The characteristics of the individual here meant that she had experienced short-lived distress and inconvenience. It was a tax liability that she was always going to have to pay, so there was no financial loss. However, the service wasn't good enough. The firm gave her incorrect information and missed a number of opportunities to rectify it. I directed that the firm recognise the distress and inconvenience in this case by making a payment of £400 to that complainant. However, approximately 2 years ago, I dealt with an almost identical complaint where the firm provided incorrect stamp duty land tax liability information all the way through the retainer. Again, it wasn't until the day of exchange and completion that the firm realised their error and confirmed to the complainant that he actually needed to find an additional £7,000. The difference here was that the complainant had no means to pay this and spent several hours in a panic borrowing from friends, family, and also getting a short-term loan. The impact here was greater and resulted in a much longer period of stress and worry. Again, the liability was something that the complainant had to pay. However, in this case, I directed a higher award for the distress and inconvenience of £750. On a final note on this slide, I just want to say that when determining whether service was poor, the starting point is to consider what should have happened and then what actually happened. If we do find poor service, the next consideration is what was the effect of this? Was there any detriment caused to the complainant which now needs to be put right? Remember, even if something is poor service and is clearly identified as such, it doesn't necessarily follow that there will be a remedy required. There has to be a flow. The service causes an impact which then dictates the remedy. Where possible, we try and put people back in the position they would have been in had the poor service not occurred. Where this isn't directly possible, we may look at compensation for the emotional impact that was caused. When it comes to remedy, there are a number of different options, as detailed on this slide. As I said, our aim is always to put the consumer back in the position they would have been in had the service failing not happened. We do recognise, however, that this isn't always possible. At first tier, you can consider some more creative options, maybe flowers or a voucher or a payment to charity or an apology. Often by the time a complaint comes to us, these options are less likely to result in the complaint resolving. At the Legal Ombudsman, we can award up to £50,000 in terms of financial loss, so that's direct and provable loss. In respect of a refund of fees, we're not limited to that £50,000. Then we could look at non-financial loss, and again this would be included in the £50,000 limit. It's unusual that we would award an amount more than about £1,000, but it does happen, as we'll see in some later slides. There are also occasions where we may recommend that actually the service provider should do some work to put matters right, or sometimes to pay for somebody else to do work to put matters right. So at this stage, I thought it would be useful to talk through some examples of determinations that have been made at the Legal Ombudsman and any remedy that's been awarded as a result of that determination. So this case is actually a case where we concluded no poor service. So if the service has been reasonable, we'll make a decision of no poor service. The case study includes Mrs. F here, who instructed a firm to assist with the purchase of a property, but she complained about unreasonable delay. The Ombudsman in this case concluded that the firm's service was reasonable. Mrs F in fact complained that the firm's approach to proving where some deposit funds had come from had caused a delay. Mrs F said that it was originally agreed that a screenshot of her savings and balance would be sufficient, and that the firm should have known from the start that additional information was needed. The firm said they didn't know that the screenshot provided wouldn't show Mrs F's full name and account number, so they then had to ask for further information. This did cause some delay. However, we're aware that firms have to follow strict anti-money laundering rules, and it's not uncommon for them to seek to clarify information. In this case, the Ombudsman was satisfied that the steps that the firm took were reasonable. Example 2 is in respect of fee-related remedies. If we decide that a firm's cost information has been unclear, then we can direct that the firm reduce or refund fees. A refund will usually be in proportion to the level of poor service. This case concerns Mrs G. She was the joint executor of her late mother's will, along with the firm, and she complained that the firm's fees were excessive. The Ombudsman in this case decided that the firm should refund 20% of their fees to the estate. The total costs for administering the estate in this case were £57,000. Mrs G hadn't received any terms of business, client care letter, or any estimate of the cost at the start of the matter. She did receive draft accounts after 10 months, which showed that the costs at that stage were £27,000, but she received no further information on the firm's costs. No estimate was provided for future work. However, she did have access to their hourly rate, so she did know that information. The firm's service here was poor because their cost information wasn't sufficient. However, the evidence showed that the firm had undertaken a significant amount of work on the estate in order to resolve various complex issues. It was also noted that Mrs G had not queried the costs or asked for an update at any point. The Ombudsman's decision therefore reflects the level of poor cost information provided, but also the significant work that the firm had undertaken to administer this estate. Example 3 is in respect of financial remedies. So if we decide that there has been poor service, we can award compensation up to £50,000. In many cases, a lower amount is awarded. We aim to recognise the impact and frustration that poor service can have on a person. So this case study is in respect of Mr H. Mr H instructed a firm to represent him in a noise-induced hearing loss claim against his former employer. Mr H complained because he was not informed when his case handler changed, information was lost when the file passed over, his claim was not sufficiently progressed, and he also complained that the firm were unprepared for a hearing. The Ombudsman found that the handover of files and case progression was reasonable. However, the firm hadn't done enough to make Mr H aware of who was handling his case. In addition to this, the firm had also been criticised by the judge for not preparing a witness statement in time for the hearing. An award of £200 was directed by the Ombudsman in this case to acknowledge the upset and frustration that was caused. However, the award did not go any further than that, as there was no evidence that the poor service had any impact on the claim itself. Example 4. So higher remedies of financial compensation can be made where it's clear that the impact of the poor service has had a significant negative impact. So this case concerns Mr I. He'd instructed the firm to act for him in an immigration matter. They advised him to make a further leave to remain application, and that once his wife's application for indefinite leave to remain was accepted, he would be added to her status. The evidence showed that actually it was clear that Mr I would not have met the requirements for that application, and so he received no benefit at all from the firm's work. It was also clear that the firm had failed to tell Mr I that the appeal they had lodged after the failed application had been rejected. The Ombudsman in this case directed that the firm refund both their own fee and the Home Office fee for the application. But the Ombudsman also awarded financial compensation of £2,500 because they recognised the emotional impact on Mr I, and because the firm's service had placed him in a much worse position than he was before he'd gone there. Before instructing the firm, Mr. I had a good immigration history, but now he's considered an overstayer with limited options. Finally, this slide shows the broad guidelines in place in respect of financial remedies that are not linked to fees. Generally, we refer to these as payments in respect of the distress and inconvenience caused as a result of the service failing. The majority of awards we direct in respect of these payments fall below £500, and we rarely award amounts over £1,000. However, in the most serious of cases we can do, as shown by the previous example. More information in respect of how we approach remedies can be found on our website. Thank you so much for watching this webinar. Please see our other webinars on our website for information about how our business process works, how to prevent complaints, and good complaint handling. Thank you. Goodbye.